Okay. Ms. Snell, if you can announce the case name and the cause number.
Yes, Your Honor, we're here in the matter of Raven Fobbs individually and his next friend of CR, a minor, and Isaiah Robinson plaintiffs versus City of Dallas defendant, cause number DC-2007-347.
We're hearing a motion to compel, is that correct?
Yes, Your Honor, that's correct.
Mr. Eaton, you want to make your announcement?
Yes, Your Honor. I'm Chad Eaton here for Raven Fobbs, Isaiah Robinson. I'm here on behalf of Larry Raleigh.
All right, we're hearing a motion to compel. Why don't we get started?
Yes, Your Honor. This case was filed in May of last year, and since that time, the parties have exchanged written discovery, and I have taken the oral deposition of Raven Fobbs. I had worked with counsel previously to get together to come up with dates of availability for Mr. Isaiah Robinson. The first date was canceled by the plaintiffs due to some conflict unrelated to the actual client. And then the second deposition, which Raven Fobbs attended, Isaiah Robinson failed to attend. It was properly noticed and agreed upon by the parties that Isaiah Robinson would appear for that second deposition.
And apparently Mr. Robinson may be incarcerated. Is that accurate?
Yes, Your Honor, that's correct. And I've actually done a little bit of research, and it appears it's a allegation for federal mail fraud. So I don't think either of the parties has any idea of when he will be able to be present. And the City of Dallas is just attempting to move this case along. We can't wait, an indefinite period of time for Mr. Robinson to be able to present himself, but it is through no fault of plaintiff's counsel that Mr. Robinson has failed to appear. So I'd like to put that on the record.
So, and is he in federal prison or is he in a jail or where is he right now exactly?
Your Honor, it's pre-trial at this moment. Plaintiffs are more aware of where they are, but it's my understanding that there has been a bail set, but Mr. Robinson is unable to meet that bail. So I don't believe he's incarcerated for his sentence at this time. It's a pretrial holding.
But is he in well, Mr. Eaton probably can tell better, but is he in a prison or is he in a jail?
It's a Fort Bend County Sheriff's Office, their detention facility, going through processing for his next step. And that is what she's saying so far is true about not being able to make bail to get out.
I mean, usually in the vast majority of cases, we're able to, if with a court order, we're able to get most incarceration facilities, whether they're usually prisons. I haven't really had a lot of cases with jails. We're able to get some type of deposition. I know it's during COVID and might make it a little more complicated, but just because someone's incarcerated doesn't mean that they can't be deposed usually. Has anyone talked to the facility there and find out what their rules are in terms of taking statements if there's a court order, or what do we need to get this done?
The notes I have is that we provided, well, first, I'm concerned that none of the mediation notices have anything referencing the criminal attorney. And it would be impossible to have a deposition of this gentleman with these kind of charges without his criminal attorney being present. And he's been included on none of the notices, and I don't show any notes where he's been contacted by the city to get his attendance or get his information to have him present for that. And he's not on the notices. So, I mean, this is 2 months ago since this last one happened, and we by no means intend to drag this out. We know we're kind of in a holding period a little bit now anyway, but with half of the depositions done, his is remaining. Honestly, Your Honor, I was kind of surprised to see this. We work with the city a lot, and a motion to compel for something, the case has just started in May, and a motion to compel already when somebody's incarcerated, it seems like there'd be a more amicable option than this. No offense to anyone. We're happy to work.
I don't blame them for doing this. I mean, they have a right to take the deposition.
Sure.
I kind of feel like that's your responsibility to kind of work those things out. She can't be talking to the criminal lawyer. The criminal lawyer is not involved in this case, right? Does this case have anything to do with the mail fraud, or it's just a car accident?
You need to be present for the deposition. just in case any questions come up about past or history. It seems like that's
Maybe.
somebody that should be present to preserve his rights, Mr. Isaiah's rights.
I don't think the city's done anything wrong here. I think what needs to happen is you guys, either Mr. Eaton, you need to communicate with the criminal attorney or the facility on how to get this done, or you need to let Ms. Snell do it. I understand why she might be hesitant because your client is represented about doing that. And so what do you prefer? Do you prefer to have Ms. Snell do this, or do you prefer to do it yourself?
It makes sense for us to do it, honestly, Your Honor. That makes more sense to me. It really does. And I'm not trying to put anything else on the city or on Ms. Snell. I'm helping Larry with this. I'll jump in for sure and kind of streamline it and make sure and facilitate, get it all done.
Now, Ms. Snell, understand that with COVID and this being a jail and not a prison, I do know that there may be some difficulties with this. And so I don't blame you for trying to get this done. And I think you have a right to try, but if, just kind of keep the court updated if you're having difficulties. A lot of times when we've dealt with prisons, not so much jails, and doing depositions, they require a court order. So if you need a court order to allow this deposition to go forward, I'm glad to do one. I think you have the right to take the deposition. Being incarcerated doesn't keep you from being deposed.
Yes, Your Honor.
But it just may be difficult given the situation in the jail and stuff like that. So whatever.
And Your Honor, I'm happy. Sorry, I'm happy to get an order setting a certain amount of time for that to happen, and I'm willing to be reasonable, of course, and how long that's going to take. So if we could get an order saying, sometime in the next 60 days, sometime in the next 90 days, that would be fine with me. I just don't want to, let it go on indefinitely.
Can I make another suggestion? And you guys may have dealt with this issue before, but as a judge, I've dealt with this a lot more than what I did in private practice. And I don't know exactly the situation with the plaintiff in this case, but one thing that I would be very cognizant of is that there's a good chance that is it Mr. Robinson? Is that his name? Mr. Robinson?
Yes, Your Honor.
That he may get transferred to a different facility. And so each facility has a different set of criteria and rules and what they need and how they do it. And, at this particular unit, you may do it through the library and the prison library. In this unit, you can only do, they all have different rules. And so I would not try to schedule this way far in advance, because he may get transferred given his status, because he's right now in a jail. I would try to find out what his process is, maybe try to find out if there's any date scheduled for him to get transferred, and try to get this done, as quickly as possible.
Yes, sir.
Because the rules change, and just be kind of aware of that.
Okay, and I'll definitely keep that in mind when we go to schedule. I was just hoping that we could have a court order in case that's required. Absolutely. And a court order that gives plenty of time for us to, schedule it at whatever facility he happens Absolutely. To be in at the time.
Go ahead and email me a court order on this. You might want to talk to, before you get me the court order, you might have maybe you guys do a joint call to the facility and find out exactly what they need. Sometimes they need certain language. Sometimes they need, and with COVID, there's even more overlay here on what might be required. And so some facilities don't have the ability to do anything remotely. And so they may require you to go in person. I don't know. So I would talk to the facility, find out what they need, and then I will provide whatever you need legally that I can to allow you to get the deposition taken.
Thank you, Your Honor. I appreciate that.
Would it be reasonable?
One last thing, that if you have the option of doing this remote, then I'm going to require it to be remote. I do not want either of you guys to go to the facility. Even Ms. Snell, I've had some attorneys who feel like they don't want to do remote depositions, blah, blah, blah.
That's not me, Your Honor.
I just don't, I've had this fight before with other attorneys, so I don't want to put Mr. Eaton at risk. And I really don't want to put you at risk either. going
No,
down. To jail the
I'm
same.
in no hurry to run down to the jail.
Okay, good. I don't blame you. I don't blame you. And I don't want to put either of you guys in that situation. So, but
Thank
I have
you.
had attorneys who I think been very unreasonable about that. And so I don't want you to, I just want you to know that we want this remote if at all possible. And something else you might want to think about, if they won't do it remote, I'm also glad to wait for him to go to another facility because he's going to get transferred, I bet, in all likelihood. And so I'm also willing to allow you to wait if you need to.
Okay.
Just totally up to you. And I'll if you can't get the deposition and you exercise due diligence, I'm glad to move the trial setting too, if that's an issue.
Okay. Thank you, Your Honor.
Would it be unreasonable to ask for, and if we do any kind of order regarding this, would it be unreasonable to ask for 120 days to make sure we are able to track all this down and get it done? I want to help and I want to jump in to facilitate it for sure, but I don't want to set a schedule I can't meet, especially with everything going on right now.
My position on that is, why don't we reach out to the jail and see how much friction we get? And if it seems like it is going to be complicated, I'm willing to extend it to that amount of time. If it isn't, I would like to go ahead and get an order, ordering it to be somewhat expedited. If it's not going to be an issue of, I'm willing to be flexible based upon what they say when we do get in touch with them.
That's great.
Great. All right. Well, we will just get me whatever order you need and email it when you have the order prepared. E-file it and also email it to my court coordinator and ask her to forward it to me, and I'll be glad to sign it as soon as possible.
Yes, Your Honor. Thank you so much.
All right. No problem, guys. I hope it all works out.
Thank you. Have a great day.
Thank you.
Bye.
Okay.
Hello?
Hello.
Hi, Ken.
Hi, Kelly.
Okay, I'm just pulling up the next hearing. I believe the next hearing is going to be a status conference on the Cook case. Do we have all the attorneys here for that?
Yes,
Kelly Akins for the plaintiff, Judge.
Kelly, you may need to open your video if you're not.
Oh, okay.
This is Ken Patterson, Your Honor. I'm here for the defendants.
Hold on.
Hello,
Do you
Mr.
see me
Akins.
now?
Is Mr. Renwick on this case as well?
No,
Okay. How about Mr. Baca
no.
or Brandon? So is it just you and Mr. Akins and Mr. Patterson? Is that it for this case?
That's correct, Your Honor.
Okay, let's go ahead and get started. And if I recall, this case is this the case that's specially set that we need to figure out what we're going to do with it?
Yes, Your
Yes,
Honor.
sir. Ken, you want to give the spiel?
Well, it's basically, Judge, it is a complex medical malpractice case involving very interesting issues that are about the retina and about the vitreous fluid, two out-of-state experts and witnesses that are going to make it last a little bit longer than most, but we had asked for a special setting simply because we want the experts to be available, but we need a new trial date because both Kelly and I believe that it's not really conducive to allowing the jury to truly understand the medical issues involved if it's done in a virtual manner. There's going to be, I have some eye models that are going to be used to help educate jurors about parts of the eye. There are various sophisticated interocular photographs and things that need to be, I guess, personally viewed in order to understand the subtleties of diagnoses and the like. It's, as Kelly and I know, and we both learned an amazing amount of information about how complex the human eye is. And so that's a spiel of the case. We'd like to get a special setting, but we'd like to, and if that's not available, that's fine. But if we need a time where we could actually present this to a jury. Would that be right, Kelly?
Yeah, I agree with all of that.
I mean, I have no problem with most of that. The only concern I really have is that we have, it's been 9 months now since we've had a jury. I've had one jury trial, a remote jury trial, and the judges are still talking about what we're going to do in terms of jury trials going forward. But there was just a new Supreme Court order out extending the moratorium to April. I imagine that might be extended again to who knows, but I'm just guessing, but I'm assuming it'll probably be a little bit longer than that before we're able to do any type of live trials. And it could be the summer when we're starting live in-person trials, but it could be quite a bit longer. So I want to be accommodating that, this isn't your fault. It's not my fault. We're just in a horrible situation. And so, you have, I guess, to be fair to y'all, but also to be fair to the, literally hundreds and hundreds and hundreds of other cases on my docket that are kind of in the same situation that you guys are. I'll give you, 3 options. One, we try to do a remote trial. 2, I'll set you whenever you like during 2021. You can kind of pick a date, but it won't be a special setting. Or I'll give you a special setting in 2022. I hope that's not going to upset you too much, but if you saw my docket at this point, I just can't justify continuing to. I understand your position that you want to do this in person. I get that, but I have to think about my other cases too. So how do y'all feel about that?
Judge, I would pick door number 2. That'd be my preference.
Which is the door number 2 is
set it sometime in 2021 at an agreeable time to us.
I think that Kelly, maybe I misunderstood. It'd be on the general docket if we did 2021, and then
all right. It'll be on. So general docket in 2021, special setting 2022 if you want.
Yeah, I may have misspoken. The general docket this year is what I would prefer.
And I would pick number 3 simply because having our expert witnesses scheduled to travel is of critical importance for both parties. And these witnesses are very, I want to say, leaders in particular training programs and particular therapies of patients that have very unusual or complex ocular problems. But I'm happy if we are on the general docket, we may be able to make them scramble at the last minute. But in my experience, it's been, if I could say I'm going to need you on this particular Thursday, they can make arrangements to do that. And obviously,
can I give you one other thing to think about? This is not an order. This is just a suggestion, and I'm not guaranteeing we could do this, but it might increase the chances you could actually go to trial. Is let's say you picked a date in September and we're back to in-person trials. One of the things that I've been thinking about, might be something that could be very useful to y'all, is to, assuming I can get a courtroom and enough jurors, is to run a double docket certain weeks where I get a visiting judge in that could try cases for me. with me. So I'd be trying one case in my courtroom and they would try another court case in an auxiliary courtroom, if that's possible. I don't know that that's going to work. I don't know if there'll be enough auxiliary courtrooms. I don't know if other judges are going to do that. And I don't really want to pick a judge that your guys are going to object to. So would that be of any interest to y'all? And that might increase the chances that you could actually go to trial on a general docket if you're willing to, if you can tell me, hey, we both agree to this particular visiting judge on this particular date. That would be another option. Now, it may be difficult for you guys to agree to a particular visiting judge, but that's another option you might want to think about. I really want to try to get you guys to trial. I understand this is an important case, and I wish I could just keep especially setting you guys over and over and over again. I understand why you don't want to do remote, though. I wish you would consider it. But that's another option of something to think about.
Judge Kelly Akins here. Do you have an idea when we might be put on the docket on a special setting in 2022?
I would set you any week in 2022. My 2022 is we have been just loaded up on cases in 2021. So we could set you probably in January or February if you want to. But right now I have on almost every trial setting in 2021, I have 10 to 15, sometimes 20 or 30 cases set. Mm-hmm. But in 2022, it's not like that yet.
Ken, I guess that'd work. Under the circumstances, I can agree to a special set in 2022.
I need to pick. Let me give you some dates then. Okay.
Okay.
You can pick them now or you can pick them later, but if you wait, they may go away.
Okay.
Ken, is my video still not up?
No, you're up. You're up. You look
okay.
Good, Kelly.
Not that I want to see myself. I just wanted to be sure. Judge Hoffman, I'm the one that crashed your hearing this past Monday.
Yeah, I remember that.
I put, I had two options. I came to the fork of the road and I took the path that should not have been taken.
So one option is January 4th, but that's a little risky because it's so close to the holidays. January 11th, January 18th, January 25th, February 1st. Yeah, any Tuesday in January, February. The one X factor I don't know at this point is there is a possibility that one of those weeks may be a non-jury week. I don't know that. I won't know that until November, probably, what the non-jury weeks are. But you could set it, and then if we needed to move it back a week, I'm happy to do that. But you could set any week in January or February.
Well, great. We could confer with our witnesses that we need to schedule, and then we would just let Rhonda know.
Let Rhonda know, but again, I would suggest trying to do this quickly. I have definitely had situations lately where somebody waits a week or two and then they call us back and the date's gone. So I would try to get back to us as soon as you can. But Rhonda, they can specially set anytime in January or February next year.
Thank you, Judge Hoffman. We will
Thank you for your time.
No problem. Just get us an agreed order on that, and then we'll go from there.
Appreciate it.
All right, guys. Thank you. You have a good day.
Thanks, Kelly.
Thank you, Ken.
Bye.
Oh, that was okay. All right. Let's go to the next hearing.
Excuse me? Yeah, okay.
Okay. Mr. Renwick, what are you here for? I don't see you on the docket.
Judge, I'm Joe Anderson. I practice with Mr. Renwick. And,
Okay.
we're here on the Tekesti and versus Pearson case, and I'm handling this hearing for Malcolm, and I have done most of the discovery and depositions.
I apologize. I missed you guys there. You're absolutely right. Okay. Sorry about that. And is your opposing counsel here, Mr. Stone? Or
That's
Mr.
it's
Baca?
me, Judge.
Mr. Baca? Okay, let's go ahead and get started on this case. Mr. Baca, if you could announce the cause number and case that we're here.
Adrian Baca and my computer just closed the cast. Adrian Baca here for plaintiff Samar Tekesta, cause number DC-19-12366.
Judge, it's my motion, if that makes any difference.
That's okay. Go ahead and give your name for the record, Mr. Anderson.
Joe Anderson.
All right, and you represent the defendants?
Yes.
Okay, go ahead and get started. Mr. Anderson, you have a motion to compel.
Yes, Your Honor. This is a personal injury lawsuit that grew out of a motor vehicle accident on August 7th, 2018, in which Ms. Tekesti is claiming injuries to her head, neck, back, shoulders, hips, and upper and lower extremities, including knee injuries. And we've learned through discovery that she was also in motor vehicle accidents, one before this one, February 14th, 2018, one November 11th, 2018, after this accident, and a more recent one on March 22nd.
Mr. Anderson, let me just say, I've read your motion. I handle these always the exact same way. So I'll just tell you what I do on these, if that's easier. I allow you to get any medical records from the accident and bills, and then medical records from any medical providers that provided treatment after the date of the accident to the same areas of the body that are claimed in this case, and any medical treatment or medical records for any medical providers who provided treatment to the same areas of the body up to 5 years, if the treatment is within 5 years of the date of the accident. So I do this the same way in every case, unless there's some very, very strange twist, which doesn't sound like it's the situation here. Does that kind of deal with your issue?
Yes, it does, Your Honor. The loan car firm represented her in some of these prior accidents, and I think Mr. Baca acknowledged they have some of the records, but they're having trouble finding them. And at the very least, if they can't produce the records, we would like the identity of all of the treating doctors from all three of those other accidents so we can obtain the records.
You can get the treating physicians if they provided treatment within 5 years of the date of the accident to the same areas of the body. So let's say they had an accident 10 years ago prior to this accident, and it was treated in the same area of the body. You're not going to get that. It's going to be 5 years prior treatment, 5 years prior to the same areas of the body.
The three accidents we're concerned with were all within a year to a year and a half of the accident. One before.
Oh my gosh, is that right, Mr. Baca?
That's correct. That's correct, Judge.
That'll be interesting.
We submitted an order for your perusal.
You'll need to modify it. I read that order. It doesn't cover this ruling. So why don't you modify it and email it to Rhonda and e-file it as well.
Okay, just to set out that we can obtain any records within 5 years of the accident. Is that
to the same areas of the body?
Okay, and what time limit are we allowing, Your Honor?
What do you mean?
Well, I hate to put that he must comply with this within 10 days if he is.
Oh, okay. Yeah, that time limit. Yeah, I'd say within 14 days of the date that they need to provide you that information within 14 days, either the identity of the providers or the records within 14 days of the order.
Okay. All right. Then I will modify our order and send that to you.
Mr. Baca, did you want to say anything?
No, I talked to Mr. Anderson yesterday about, we're having difficulty finding these files because they're in storage. So we have people looking for them. So as soon as we get them, I'll send him the information that he needs.
Okay, perfect. All right, anything else, guys?
Nothing further,
No, I
Judge.
just want to try to have everything before we have to get ready for trial, and it's getting to be kind of an old case.
Trial in 15 years.
Don't be so it won't be quite that bad. When are you guys set for trial?
We are
I'm not sure. I thought it was coming up in the spring, but I can't find a setting on it, so it may not.
Let me see. I'll look it up right now. Let's see. You guys are set. You're set on March 2nd. There's just a new moratorium on this. I don't know if you saw the Supreme Court, but they've extended it to April 1st. So you have a couple of options. I can reset the case, or we can try to get you on a virtual docket. What do you prefer, Mr. Baca?
I'd prefer to reset.
When do y'all want to reset to?
What's available to us at this point?
I'll set you whenever you want. I don't know when I'll reach you, but I mean, we'll do our best.
Let's try to reset it within the year.
Okay. When would you like to reset it?
November work for you, Joe?
November's fine.
November. How does November 9th or 16th sound?
I guess I would take the 9th if it's just because it's sooner, unless it looks like a worse docket to be on.
I mean, it's going to be tough every week.
9th works for me.
Once we start back, hopefully we'll be back by November. So, Rhonda, go ahead and reset this November 9th. Send them out a new trial notice. Have you guys already been to mediation?
I don't believe we have we?
We have not, at least to my knowledge. Yeah.
Well, you guys do need to go to mediation. And we will send out a new trial notice. Anything else, guys?
Do we need to respond with the name of a mediator we agree to? Or
well, I've already appointed one, but do you want to substitute that, or?
Okay, we can discuss that off the record then later. Thank you, Judge.
Let me tell you who it is. I can look it up real quick. Mediation. The mediation order is Nathan Majors. Y'all ever use him?
I've gone against him before.
Oh, have you? Okay.
Yeah.
I don't know him. I've never dealt with him, but
he's a good guy.
So if you want to mediate with him, you can, or you can, we can send you to someone else.
okay.
So I'm happy to substitute, but you do have to mediate.
Okay. I think we need to discuss that between us, between the lawyers.
No problem. No problem at all.
Okay.
All right, guys. Good to see you, and we'll see you on the next one, okay?
Okay.
All right. Good to see you, Judge. Thank you.
All right. Good to see you.